Weird.
Good morning, everybody. We ready to go?
Are we? Is there a few more people coming?
More.
I'm ready, Your Honor, but there's still some more people that are coming into the courtroom.
Okay, just tell me who you have.
We have right here, I have. Wait, I don't have any of them. The only one I have is
Bernard, we can go with right now.
Okay, I can do Bernard right now, Your Honor.
Let's do it. Bernard Perea.
Yes, Your Honor. How are you this morning, Your Honor?
Good morning. All right, well, my computer's all right, no Joe complaint, it looks like. Do you have a copy of it?
Yes, Your Honor.
Name
And
correctly spelled?
yes, I've gone through the information. The criminal complaint with him. His name is spelled correctly on line 7. He understands the contents and he will waive a formal reading. All
right, sir. You can plead guilty or no contest today and resolve this, or you can plead not guilty. And we'll set a first test. So what do you want to do?
No contest.
All right. Did you watch our videotape going over your rights?
Your Honor, we didn't play the video, but I did go over all of that with him prior to this because of the nil jail complaint.
Okay. All right, sir. I'll accept your plea. I'll fine you $100 plus assessments, give you credit for the time you already did, and close out the case. Thank you.
Thank you, Your Honor.
Oh, and Your Honor, I could do Mr. Lee right now. He waived his appearance.
He waived his appearance. Excellent. What is the state feels program this minute?
Yes, Your Honor. In this case, we are asking for $7,500 bail for Mr. Lee. I think the criminal history going back to 95, had misdemeanor convictions in Arizona in that year, felony convictions for theft in 11 in Arizona, 12 for failure to appear in Arizona, has numerous failures to appear in his history. Looks like he came to our area in the late 20-teens. Recently this year, he had a possession of drug paraphernalia conviction from the 24th of December, misdemeanor conviction for petty larceny in Sparks Municipal Court, also in 25. Misdemeanor conviction for possession of drug paraphernalia here in this court in 25 for credit time served. 23 had a misdemeanor conviction for petty larceny in Reno Justice Court. Also had a traffic ticket that he was convicted on with 2 failures to appear. Has lengthy issues with substance abuse. Most recent felony conviction for substance abuse was in 2019 with sales of a controlled substance down in Douglas. He has a few other cases in Douglas in the late 20-teens as well. So again, risk not to appear given his failure to appear history, risk to continue the conduct given lengthy history with controlled substances. Ask that bail and supervision and testing be imposed. Thank you.
All right, defense.
Your Honor, I'm going to be asking for an OR release today with conditions that I think can be fashioned to ensure safety to the community, as well as future court appearances. Mr. Lee, looking at his criminal history, I don't see any crimes of violence in his history showing that he's not an individual who's a threat to the community. He's an individual who goes out, obviously, and does substances and then makes bad choices, but his choices have never been anything violent. It's been things such as stealing and such to control this addiction. Control his for his habit. He's been in the area for about 10 years, which is a pretty long time, showing that he does have substantial ties to this community. With that, Your Honor, I am asking for an OR release with drug and alcohol testing, and I will submit on that.
All right, thank you. The state shown by clear and convincing evidence that bail outside the defendant's ability to make necessary to ensure the safety of the community and appearance of the defendant. Therefore, be set as requested. Obey all laws, make all court appearance. Defendant's next court date is January 9th at 9:30 a.m. We'll see him then. Thank you.
And Your Honor, I can do Mr. Hale next.
All right, let's do Mr. Hale. What does the court feel is appropriate on this matter?
Yes, sir. So regarding Mr. Hale, we're asking for $25,000 bail, supervision, no contact with the victim, Samantha, and my advocate indicated that her last name is spelled capital D apostrophe Arey, DeArey. The defendant has concerning criminal history going back to 2013. He had a felony conviction for robbery second degree in Stockton, California, had 4 parole violations and a parole revocation in that case. 2016 felony possession or felon in possession of a firearm with a gang enhancement in Stockton. He also had a parole violation on that case. 2018 had a felony conviction for possession of sales or possession for sale of a controlled substance here in the second judicial. Also had a trafficking arrest that appears like it was no issue, possibly a joint resolution there. Had a 2019 misdemeanor conviction for resisting in Placer County, California. Had a 2021 disturbing the peace that was down from a domestic battery in Reno Municipal Court, as well as a false statement obstructing in Sparks. 2022 had a felony conviction for pandering here in the second. Also had another pandering arrest in 23. It looks like it was ultimately dismissed. Again, probably a resolution the way it looks. And then recently had an arrest for obstructing in Redding, California in 25 that I don't show a disposition for. In addition to the bail, the supervision, no contact with Miss DeArey, and we would also ask for no weapons given the one, he's a felon, and two, the indications of weapons in this case. And with that, I would submit it.
Make sense?
Your Honor, I would ask for an OR release, or in the alternative, bail that he would be able to afford, that I believe is appropriate. I would ask for bail in the amount of $5,000. That way he does have to post up some money so that he has something to lose, which will have him make his future court appearances. Looking at this case itself, what he is facing right now is a gross misdemeanor. So if he does not, he's not facing a felony, it's nothing like that. So he would not have as big of a reason to flee as if this was a prison sentence that he could be facing. We have been in contact with his friend named Brianna, who has confirmed that he does live right now. He does have an address, but it is in Stockton, California. So they will know where he is at all times. He will have no problem checking in, and I do feel that a no weapons clause is appropriate with this case. With that, Your Honor, I'll submit.
All right, thank you. The state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community. Appearance of the defendant will be set as requested $25,000. No contact with victim. Separate criminal offense pursuant to NRS 1784845 to the maximum 120 days. No firearms. Check in with Washington County Pretrial Services as ordered. No bail laws. Make all court appearances January 9th at 9:30 a.m. is the defendant's next court date. Seen that.
And Your Honor, just to confirm, is there a 10% cash option for this?
There's always a 10%.
Okay.
And of my cases.
So my bill is at $25,000.
Yes.
Yeah, or 2,500 cat.
Stop talking. Talk to me. You're gonna, if you post $2,500, you can get out. You're gonna go back.
You gotta go back.
Yeah, you're gonna go back. I think everyone's here, right? Everyone's here, Your Honor, so we can proceed in whatever order you'd like.
All righty. Looks like Anu and then Campbell.
Mr. Anu, you're gonna come next to me. Do you need an interpreter? Do you understand English, okay? Do you need an interpreter?
It's okay.
Are you sure? Okay, come stand here.
Make a recommend.
Your Honor, I did ask if he needs an interpreter just because I feel like there might be some confusion when I'm talking to him. He's indicating he'll be okay, but I have to be honest, I'm not totally sure if he's gonna understand everything.
Sir, did you understand what your attorney said?
What is it?
He asked if you understood what I was saying.
No.
What is your native language?
Juke.
Sorry, I didn't hear that.
Juke?
Yes.
He said juke.
What country is that language spoken?
I don't
Sir?
know.
You don't know?
I don't know.
Where were you born?
Juke.
Your Honor, my colleague did some research. It's a country in West Africa.
West Africa.
Yeah, it's a West African
Duke?
dialect. Yes.
Never heard of a country called Duke.
Country.
Sir, what other countries is that next to?
So Juke's not the country, that's the language spoken.
Yeah, I need to know the country that he's from.
Do you know the country?
And,
What country were you born in? You don't know?
Well, the map and you just look at the map. What to?
So here's there may be a
Your Honor-
competency issue because
Your
he
Honor,
doesn't. He doesn't have an accent. He can't tell me where he was born. So
It's a slang.
I'm gonna
Your
go
Honor,
ahead and continue.
So according to his criminal history, he was born in the Federated States of Micronesia. He does have some criminal history out of Hawaii, so I'm not sure if there's a if that's maybe more accurate as far as his if it's a native language, it may be a competency issue again, but
Sure, I'm just concerned that his answers to my questions.
Yes.
And so I'm gonna set it over to allow the attorneys to talk to him a little more.
Yes,
We'll get the criminal complaint, see if there's an SB 89 issue.
yes, I think that's appropriate, Your Honor.
All right, we'll see him Tuesday to give you some time to talk to him. Campbell
You're gonna go back.
and then Cole.
Thank you.
You're welcome. Mr. Campbell? You're,
He's hard of hearing.
yeah. And Your Honor, Mr. Campbell is hard of hearing.
All right. Mr. Campbell, you did apply for the services of the public defender. Do you want to apply for a public defender to represent you?
I'm not able to hear.
Do you want to apply for a public defender to represent you?
Yes,
He does, Your Honor.
All right. What is your weekly income?
pardon me.
What is your weekly income?
It's monthly, 967.
All right, I'll give you the public defender.
Yeah,
What does the state feel is appropriate on this matter?
pardon me.
yes, Your Honor. So
Can't hear.
with
Sir,
With
you
Mr.
can't hear. Here's what we're gonna do then. We're gonna bring it down in person tomorrow. And we'll do this because we don't have any, sounds like the jail doesn't have the headphones that we do for the hearing impaired. It's an issue that we have to address. And so we'll just transfer you tomorrow. We'll do the arraignment here. Or sorry, the bail hearing. We'll see you then. Thank you.
They're gonna bring you tomorrow in person with headphones.
and Your Honor, will that be
Roman Gonzalez?
sorry, Your Honor, with well, briefly on Mr. Campbell, will that be at 9:30 then or at 10 when his hearing is tomorrow?
It'll be the 9:30 in custody.
Okay, I would
9:30.
like the judge to know I have a medical emergency that I've been trying to get addressed.
Okay, we'll talk to you tomorrow about that. Thank you.
Herniated-
I would let the jail know, though. They're the best people to deal with your medical emergencies. Cole and then Roman Gonzalez.
Oh, Your Honor, Mr. Cole waived his appearance, but I'm prepared to proceed.
What does the state feel is appropriate?
Yes, Your Honor. So with Mr. Cole, we are asking for $10,000 bail, conditions of supervision and no weapons. So I show that this defendant scores an MPRI score of 15. The criminal history I received only contained Nevada criminal history, which just shows his petty larceny arrest that he was in custody for. I note that it does indicate, obviously, a high total, including prior convictions. I was attempting to try to see if I could get someone to double check the criminal history I have and unfortunately, I just wasn't unable to get that done or hear back from my office this morning with our investigators. But it appears to me that he's got a restraining order out of California, which indicates to me that he must have some California criminal history that for some reason just did not show up on the criminal history I show. But given the high MPRA score and what is contained in that, as well as the apparently find the probable cause sheet unprovoked and random violence. Um, uh, we do believe that bail is appropriate, again, asking for that $10,000 and no weapons and supervision. So with that, Your Honor, I would submit it.
All right, defense.
So, Your Honor, with this case, the only criminal history that I see is the petty larceny from 2026. So I'm not sure where the other criminal history is coming from. In regards to this case, he was only in for the petty larceny out of Reno Municipal Court. He did get into an altercation with his cellmate, but our client is coming down pretty hard from some detox, which I'm sure caused a lot of frustration in that cell. From what I see in this criminal history, he doesn't appear to be a threat to the community or anything like that. He waived his appearance also because he does have a pretty bad spider bite on his hand that I did see festering really bad. So I do think he needs to get medical attention for that. He is only dealing with the petty larceny case. I do feel an OR release is entirely appropriate in this matter. And with that, I'll submit.
All right, defendant scores a 15 on the risk assessment tool, which means he's in the, at best, 50th percentile of making his court appearances remaining crime-free. The state has a compelling interest in both of those. So therefore, the state shown by clear and convincing evidence the bail is necessary to ensure the safety of the community appearance of the defendant will be set as requested, $10,000. Bail law make all court appearances January 9th and 30th the past next court date. We've seen that. Roman Gonzalez.
Roman, you come next to me.
What does the state feel is appropriate on this matter?
Yes, Your Honor. So first, I would note we had tried to reach out to Mr. Mendoza. I know I did not hear back as far as a statement. However, we're prepared to go forward today, given the fact that we continued it from yesterday. Your Honor, in this case, the state is asking for $250,000 bondable only bail, given the extremely concerning nature of these charges. The defendant has some criminal history. One, a 2019 misdemeanor conviction for DUI in Virginia City. Then it appears that he was in Georgia for the past couple years. He had a misdemeanor conviction for possession of marijuana and possession of drug paraphernalia in Winder, Georgia. And then a misdemeanor conviction, it says battery family violence in Barrow County, Georgia. That was in 25. Again, given the recent out-of-state ties, it appears from the statements here that he was even indicating that he was essentially destined for California, the way it appears to me, that he was just kind of stopping over here in Reno where this crime occurred. Therefore, we believe, given the very serious nature of these charges, the relative lack of ties to this community, given that its ties appear to be these family members that are now obviously victims, as well as I think there was a reference to an uncle, but appears that uncle was not exactly thrilled with the defendant regarding these allegations. So lack of ties to the community, recent convictions out of state, as well as just the dangerousness to the community with a crime such as this on a extremely vulnerable victim. We believe that high bail, essentially detention order, is appropriate, as well as if he were to make that at some level, GPS monitoring, as well as no contact with the victim. I would just give her initials as CM, and that 2334 Wedekind Road address. It may be appropriate if he makes bail also to have some sort of testing. It appears he tried to blame some of this incident on not being fully cogent due to marijuana use or some other sorts of substance abuse. And again, he does have substance abuse in his history. So that may be appropriate as well. But again, concern for this victim, the community, as well as concern to flee the jurisdiction. And so we believe that a high bail is appropriate. Thank you.
Thank you, defense.
So, Your Honor, with this case, it's correct. He is facing some very, very serious charges, perhaps some of the most serious charges one can be charged with. But as of right now, he has not been proven guilty by any trier of fact whatsoever. He does still deserve the presumption of innocence. And with that, I do think bail is appropriate, but I do not think $250,000 is appropriate. I do think bail set at 100 to about maybe even $150,000 is appropriate, with other conditions that I believe can be fashioned to ensure safety to the community as well as future court appearances. He has informed me he does have a friend who resides locally that he can stay with. He doesn't remember the address off the top of his head just because he's not from here, obviously, and doesn't remember the addresses very well. But that friend will let him stay there with him. He couldn't remember the phone number because it's in his phone book, in his phone that was taken, so it's right now in his personal property. A no contact order is entirely appropriate, meaning that he will not be in contact with the alleged victim of this case at any point or time, as well as a stay away order. Mr. Roman Gonzalez can also do a GPS monitor, and that can be fashioned for him to stay at his friend's house. So he will be residentially confined for the entirety of this case. Drug and alcohol testing is entirely appropriate because there is a big nexus with drug and alcohol testing here as well. He also does have 10 years of welding experience behind him. So when he gets out of custody, he will be working. He's going to be keeping himself busy, and he will be able to help his defense and able to help his defense with these charges, with whatever way this is resolved eventually. Your Honor, with all that being said, I am asking for bail in the amount of $100,000 or to $150,000 with those conditions that I just asked for. And with that, I will submit.
All right, thank you. Unfortunately, there's no peer-reviewed evidence that house arrest or GPS monitoring does anything to ensure the safety of victims or the community. Therefore, the only option in this case is set bail outside the defendant's ability to make it. That'll be $500,000, no contact with the victim, separate criminal offense pursuant to NRS 178-4845 for the maximum 120 days, ankle bracelet in place before release, residential confinement in place before release, random drug and alcohol testing, check-ins with Washington County Pretrial Services as ordered of bail laws, make court appearances January 9th at 9:30 a.m. is the defendant's next court date. See you then. Anybody else have the jail?
No, that's everybody, Your Honor.
All right, have a great Sunday. Thank you.